Good afternoon, everybody. My name is Chris Justice, and I am here today again to join you all for Employment Law Q&A. As many of you know, I'm an associate who works with Samfiru Tumarkin, and I work out of the Toronto offices. And I'm here to hopefully answer as many questions as I can for all of you, all things employment law related. And as I normally do on the early part of my episodes, I have a couple talking points before I get into some of the questions. And so today I want to start off by speaking briefly about short-term service employees who are subsequently let go and terminated from their position. And when I say short-term service employees, I mean employees who have been with their employer for maybe less than a year or two, or maybe a few years at the most. And the reason why I want to talk quickly about short-term service employees and their severance entitlements is because there is a misperception or misconception that these employees may not really be owed that much as far as severance is concerned. And so I want to dispel that myth by generally making the point, first of all, that if you're someone who's been with a company for even a couple months, let alone a couple years, you could be potentially entitled to severance that amounts to several months. Again, even if you only have several months of employment with your employer. And I want to raise sort of a real life example that I had recently where one of my clients, he was in an executive position. He was making a good amount of money, about $200,000 a year. So definitely high up there. And he actually got a job with a company as a financial advisor. And he worked for that company for a total of about 30 days. So that's 1 month. And he was let go from his position during the probationary period. And he was essentially afforded or given 1 week of severance from his employer. Now, he came to me and we eventually started a lawsuit on his behalf. And sort of fast forwarding to the point where we settled, I was able to effectively get this man 4 months of severance tax-free. So I say tax-free, meaning it actually would then reflect probably closer to upwards of 6 months of compensation. And again, this is a guy who had 30 days roughly of employment. So that just goes to show right off the bat that you can be someone with very little service, but still potentially receive a very significant amount of severance. And in this particular gentleman's case, some of the factors that were working in his favor, number one I mentioned was the position that he had. So it was a very senior role. And even though he was there for a month, it ended up taking him several months to find a job that had comparable earnings. And that's another key component of severance, is the idea of how long it should take someone in your position to find another job that's comparable. So regardless of whether or not you're with a company for a day, a week, or a year, if you have a a certain a level of a job in terms of a fairly senior role, it's going to take you, no matter what, probably at least a few months to find another role, because there's going to be the interview process. There may in fact be multiple interviews that you have to go forward with. And so really from the time you apply to the job to the time you land the job at a more senior level, we could easily be talking 3, 4, 5 months time. So that was one factor that played a role. Another factor, which is very important, is that this gentleman did not have a contract, or at least did not sign a contract that had any language in it that would have limited his rights. And so even though short-term service employees can typically get large severance packages, it will in part come down to, of course, as always, what is in the contract, what the contract says. But I just kind of want to start off today's episode with, giving those of you who may not be with employers for very long, more of a glimmer of hope as far as actually you are potentially entitled to significant severance. So if your employer has offered you 1 week, 2 weeks, 3 weeks, and you're thinking, well, I was only there for a few months or a year or maybe a little over a year, don't assume that that means that that number that's been offered to you is anywhere close to what your employer actually owes you. And if you are particularly in a situation where you're of a senior level and you're let go relatively quickly, definitely give us a shout, because again, your severance entitlements could be quite significant. So that's number one. I kind of want to start off today talking about short-term service employees and the fact that they actually have potentially huge rights and entitlements. The second thing I want to talk about just relates to the ongoing COVID pandemic, and relates to this whole idea that employers are implementing vaccine policies and letting a number of people go for failing to comply with those policies. So if you're if you're an individual in a situation, and I know I've said this before, but I'll repeat myself, and you have been either terminated from your job or placed on some sort of a suspension or a leave of absence for failing to meet the company's vaccine policy. Again, don't assume that you don't have rights or entitlements in those cases, and there's a very good chance that you, in fact, will be entitled to severance as though you had been essentially terminated on a without cause basis. Now, there have been recently some decisions that have come down in the unionized context, where certain grievances were processed by employees, making the argument that the vaccine policy was unreasonable and that they're therefore entitled to severance. And there have been a number of decisions, again, in the union context, that the arbitrator decided the policy is reasonable, and therefore you're not entitled to any severance. And some of you may have been reading some of these decisions, these grievances, these union cases, and maybe thinking that because of these cases, I myself, who may not be a unionized member, but who was punished for not complying with the policy, maybe I'm not entitled to anything because these other cases over here essentially concluded that the policies were reasonable. And while that may be a factor to consider in your case, again, don't assume that just because you've seen or heard about a case where a policy was actually held to be reasonable as far as vaccines are concerned, that therefore applies to your situation and means that you have no recourse. So if you're someone in those situations, again, give us a call, contact our firm. We'd be more than happy to go through with you the process, analyze your case, and kind of take you through all the risk factors. And again, as I've said before on this Q&A in the past, your severance entitlements could be extremely significant. So that's something you definitely want to pursue. So you can contact us down below. I've mentioned the website, or you can also give us a call at any time. And our associates, whether they're in Toronto, Vancouver, Ottawa, Alberta, can definitely help you out and take it from there. Having said that, those are my two talking points just to start today's Q&A off. Please do get your questions in. As I always do, try to answer as many as possible. And so I'm just going to go now through some of your questions, and we'll go from there. So the first question or statement comes from David Walsh on Facebook, and David's interested in learning about wrongful dismissal. So first of all, David, for me to give a lecture or a lesson on wrongful dismissal, I'm not going to be able to do that in the short amount of time I have. But what I will say is, generally speaking, a wrongful dismissal happens where either the manner in which you're let go is being done in bad faith. So an extreme example would be you're let go from your job and you're sort of paraded through the office, and everyone knows that you've been let go. Maybe there's an element of humiliation there. Maybe you're not really given any chance to collect your belongings and you're just kicked out. That could potentially be an example of a bad faith manner in which you were let go. Or perhaps you were let go based on discrimination, based on a protected ground under human rights. That's going to be a wrongful dismissal as well. So that's one aspect of what a wrongful dismissal could involve or entail. Another aspect of what a wrongful dismissal could involve is just simply the fact that you were not given an adequate severance package. So normally when people are let go without cause, they're offered a severance package by the company. And most often that severance package is not going to be fair and reasonable, and it is going to be very low. And so someone who, let's say has 10 years of service, they may be offered a 5-month severance package. And meanwhile, I'm telling that person that they could get more than a year of severance. And so it makes therefore sense to pursue a greater amount of severance. So in situations where an employer offers you far below what you're reasonably entitled to, that could be another aspect or another way of describing a wrongful dismissal. Um, David, if you have any other specific questions about wrongful dismissal, definitely get in touch with us. Check out our website. We've got a lot of frequently asked questions as far as wrongful dismissals are concerned. And so that can probably flesh out some answers for you. If you have a particular situation that applies to you specifically that you can't find the answer to, then, as I say, definitely give us a call and be happy to take you through it and find out if you've been wrongfully dismissed, what your entitlements are in your situation for a wrongful dismissal, and go from there. So I appreciate I gave a general answer to that, but hopefully that gives you some idea. And as I say, happy to help out further if need be. I've got another question or a comment in from Kevin Byers on Facebook. Kevin's saying that he has a slight disability, which his employer has taken into consideration. So that's good to hear, first of all. Recently, there was a job posting for a position that he was interested in applying to. He doesn't have experience in that area, but he's willing to learn. And he's asking, how do I determine if I do not get the job because I have no experience or because the company is not willing to accommodate my disability? And that's a good question. And this could apply for anyone who is starting a fresh job or anyone who is looking to maybe transition within the company to another position. And the general answer to that, Kevin, is it's going to be probably quite difficult to tell the reason for which you were denied that position. Obviously, you can ask, and you can ask just out of general curiosity, or you can ask them just in the spirit of trying to better yourself or understand the situation better so that maybe next time you can be in a better position to get an opportunity like that. So I would say there's certainly no harm in asking if you don't get the job, what the reason was for that, and if they can give any potential constructive criticism, whether it has to do with your experience or whatnot. But to apply also to a job that you have no experience in, it could be very easily the case that the employer denies you just simply on the basis of a lack of experience, or because there are maybe more suitable candidates that the employer is considering. So again, it's going to be quite difficult, I would imagine, to find out the real reason if the company's not being honest. And of course, the company is not going to state that they didn't want to accommodate your disability, and that's the reason. So I think it would be quite an uphill battle for you to actually prove it, unless you can kind of put together all the pieces and come to a reasonable conclusion that there's something about that job that maybe is different than the job you have. And then maybe you can kind of, again, it's tough, but maybe speculate or sort of draw a connection to why they didn't give you that job. But again, it's going to be very difficult. So I don't know if there's a whole lot you can do other than just ask, but that's all I can really say at that point. And to allege that the company was acting in a discriminatory fashion, of course, they're going to deny it. So you're going to need quite a lot of evidence, I would imagine, to really convince them otherwise, or at least convince their lawyers otherwise. So if you do have a number of pieces of evidence, circumstantial, otherwise, that may be something to chat with us about. Because you also don't want to necessarily go down that path if it's going to be a difficult challenge and potentially cost you a lot of money as well. So that's generally my answer when it comes to those types of questions. Hopefully, I answered it to the best of or satisfactorily to you, I should say. But if you have any further questions, by all means, send them my way. I'd be happy to help out if I can. Archie on YouTube is asking, how do you prove a human rights issue in the workplace? I'm often treated differently than other staff and not given the same opportunities. And yeah, sort of related to Kevin's earlier question, it can be very challenging to prove that there is discrimination going on within the workplace. And actually, a lot of people, in my experience, sort of, like they say, or like you're saying, Archie, you're saying treated differently. So there have definitely been a lot of clients of mine or individuals that I've spoken to in the past who have told me that they've been treated differently than others. And first of all, one of my questions is, why are you being treated differently? Are you being treated differently because like a manager within the company doesn't like you? Are you being treated differently because, of your skin, of your age, of your gender? Like if you're the only Black person within the workplace and everyone else is being accommodated, that could be different than if it's not the case and someone just has some kind of an ill will or disliking towards you. So it's a question of treated differently. How so? If it's on the basis of a ground that's protected under human rights, like I mentioned, race, age, gender, marital status, childcare commitments, that kind of stuff, and others in the workplace who are being given opportunities don't have those same issues to contend with or to deal with, then that could potentially suggest a human rights issue. But again, it's really a matter of building up that case because the employer is most certainly going to deny it. But the other thing too is just to ask and to be as transparent as possible, and maybe say, why aren't I being why aren't I given those opportunities? Why is it that I can't do this, that, or this, but others can do this, that, or that? And so it could be helpful to actually try to get an answer from the company as far as what the rationale is. And it could work out to be the case that it makes sense, or it may be the case that what they're saying doesn't make any sense, which could then, further raise your suspicions about a potential human rights claim. So I would probably ask the employer first, get an understanding of why it is you're not being offered those things, find out what their position on the matter is. And then from there, if you still have a strong suspicion and some, solid basis for that suspicion, then there could definitely be a human rights concern there. And it could be something that you want to pursue further. And if so, again, as always with everyone else, give us a call and we can sort of talk you through it, take you through it, and figure out kind of what your options are at the very least, depending on which direction you go in. Got some more questions in. I've got one question from JC on YouTube who's asking, do transportation related mandates extend to logistic warehouses, sorting, packing, loading vehicles? So that's a good question, JC. And that brings up a more general point that I've found recently in my practice, where, employers are, of course, trying to establish legitimacy with their COVID policies. They're trying to obviously make it the case that they're either mandated and they had no option, or just legitimize their actions in some way. And I've actually had and do have cases where clients of mine sort of work in we'll call it the transportation industry, which is a pretty broad, I think, umbrella. But I do think that there is a difference between, a driver in the transportation industry, or maybe a railway conductor, or, someone who's on a cruise ship, or someone who's, sort of in the airline industry, obviously. And then comparing that to someone who's in a facility, a warehouse facility, who, as you say, is sorting, packing, loading vehicles. I mean, it may be in the same general industry, but I think part of the rationale behind why, for example, airline employees are, or at least were mandated to get vaccinated, is because they're in an airplane in a tight sort of space, confined space with others. But you may be someone who works in accounting for an airline, and it just may not have the same kind of essence to it. So I think that's a legitimate question, JC. And I would definitely not assume that just because you work in sort of the transportation sector, maybe technically speaking, that you're therefore going to be treated identical to, maybe someone who's, working more closely in terms of transportation itself, transporting goods, people, that kind of thing from spot to spot. So if you're someone who's in a sorting or packing facility, and you're being told that there are mandates and that you have to comply with the policy, otherwise you're going to get nothing, then that definitely to me seems like a situation where you're going to have a greater chance of getting severance, and depending on the situation you find yourself in, potentially very significant, upwards of 2 years of severance. So for you, JC, or anyone else who's in that scenario and they're being told, we've been mandated, again, don't assume it's necessarily the case or that the company has the right to actually terminate you for just cause, even if there is a mandate of some sort in place. You want to get in touch with us and contact us online or through the phone. But thanks, JC, for your question. We've got another one from Hai Tran, who's asking, hi, I've been working, and this is through YouTube. Hi, I've been working at the same company since 2003, working 40 hours a week. And after COVID, they only let me work 3 days a week at 20 hours. And I only get paid minimum wage. I don't know if it's worth it. So first of all, and this applies to anyone, COVID, non-COVID, doesn't matter. If you're working 40 hours a week and your employer says, due to COVID, we can only have you now work 20, and they essentially cut your work week in half in terms of wages and days worked, that is, in all likelihood, going to be considered a constructive dismissal. Unless you've agreed to it, even if there is a business reason associated with that change, that's going to be a constructive dismissal, and you're going to be owed severance. Now, there could be an issue in terms of a lot of time has passed since that change was made. You're saying after COVID, they only let you work 3 days a week. So I don't know if that means you've been working 3 days a week for the last 2 years, or if that means they more recently made changes to your employment in the last few months. But you definitely want to get in touch with us ASAP on an issue like this, because the more time that passes and you're just working those 3 days, you're going to be viewed as having accepted that change, or at least potentially viewed as having accepted that change, or condoning the change. So get in touch with us ASAP, because any significant change to the terms of your employment, if it's not made through consent, it is going to likely trigger a constructive dismissal for which you are owed severance. And you've been working there for quite a while, since 2003. So we're coming up on almost 2 decades of work there, and your severance entitlements could be upwards of 2 years. But it's just, again, a question of whether you consented and how much time exactly has passed, and also whether you've complained about it and sort of made it known to the company that you do not agree with that change, which I would also advise, people in a similar situation. If someone's affecting a change on you ASAP, especially if you don't obviously want to agree to that change, putting it in writing, sending an email, sending a letter saying, I believe this is a significant change to my employment and I don't agree to it, I'm not consenting to it, then that's, I think, very important. So Hi Tran, definitely give us a shout, just so that we can make sure you take all the necessary steps moving forward and don't do anything further that could potentially affect the case in a negative way. But thank you for your question. I think it's important for everyone to know that they don't need to accept these changes, even if it's in the context of COVID, and even if your employer is otherwise trying to rationalize or legitimize their actions. But thanks again for that question. I hope that answers it. I've got another question from Paul Marks on Facebook. Paul's asking a question regarding being treated unfair at work. So team leads are saying hurtful things. There's harassment at work. They won't let Paul work in advance in training and upgrade his skills. What's the best thing to do in this case, as human resources doesn't seem to care? And again, another good question. This kind of goes back to constructive dismissal, which I was just talking about a second ago. But as part of everyone's employment in this province, you're to be treated with civility, dignity, and respect. And that doesn't have to be written down anywhere. That's just an implied term of any employment situation, is to be treated in that way. So if you are someone who's being harassed at work, bullied at work, belittled at work, God forbid, assaulted at work, I mean, these are all flagrant examples of there being a breach of civility, a breach of your dignity, a breach of, these implied terms. And of course, no one needs to stand for that. And you should make your voice known. You should stand up and say, this is unacceptable. This needs to change. And it seems like you have already done that with human resources. Now, I don't know if you've put your concerns or issues in writing, but I mentioned this a minute ago. It's always good to put things in writing. And if you have done that and HR doesn't care and they're brushing your concerns under the rug, then that can only make things worse for the company. And you actually may have an ability to leave that place and essentially quit in a way, but get severance. Now, I wouldn't recommend that you say anything to them right now as far as you quitting, even if you think it is for legitimate reasons. That's something you want to talk to a lawyer about first. But there may be an ability for you to exit that situation and get paid severance. Or it could possibly make sense to take some further steps to find out what, if any, investigations have been done, and to get a better sense of what the company's response is, because they are generally obligated to keep a safe and healthy work environment, and that extends to making the work environment harassment free. Most companies have anti-harassment policies, so there may even be a policy with a specific process that you have to follow in terms of reporting things of that nature, and that may be another starting point or an area you want to look at, just so that you can say later on, hey, I came to you guys with a concern. I followed the company's policy. You guys responded by dismissing it. And again, that might give you even more options to potentially get a large severance package. Or if you want to keep your job, there's also the ability to try and negotiate something in that sense, and have the work environment just reinstated back to a healthy state and not be maybe as toxic as it is. But thank you for your question. I think, again, that's another important one that everyone needs to be aware of, and to know that that's not something they should stand for, and to get in touch with a lawyer soon so that you can cross your T's, dot your I's, make sure that you don't say or do anything that could potentially jeopardize your case, and just kind of paper your trail accordingly. So hopefully that answers your question, but thank you for that, Paul. Heino Arniak on Facebook is stating, with all the new information coming in about adverse reactions regarding vaccines, will this help people who were let go due to not taking the vaccine? So generally speaking, when it comes to the science, as far as the vaccine is concerned, when it comes to any kind of political view, that for the most part is not as relevant as the point about whether or not there's actually a government mandate that requires the company to have its employees vaccinated. That's a huge part to all these vaccine cases. Is there a law on the books that says, for those of you in your company, the one you work at, that all these employees have to be vaccinated? Because for the most part, the vast majority of industries or situations, there's not. There are recommendations from the Ontario Medical Chief Officer, for instance, but there's not an actual mandate. So that's the main thing that people need to be focused on, and not get too into the weeds with these other issues, although they can be, legitimate and helpful to know. It really, a lot of it boils down to what is the state of the law, and what's essentially the legal basis for them doing what they did. Is there anything that would authorize a company to terminate someone for cause and pay them nothing after a long, lengthy service for choosing not to get vaccinated? And the answer to that is most likely no. Now, the state of the world and the timing in terms of when you're let go or when you're suspended, and what's going on in the world at the time you were let go, can definitely be important. A lot of people have come to me who were, say, for example, let go in October of last year for not getting vaccinated. And they're telling me, hey, Chris, now that things are changing in March, April of 2022, is that going to have an effect on my case? And my general answer is, again, it's more about the timing of what they, of what happened when they actually let you go or when they put you on an unpaid leave. So in that case, it would be, say, late last year, and not so much what's happening in the future. Because courts are generally not going to penalize someone, an employer, for example, just because something happened a year down the road that maybe they couldn't foresee. It can still help paint a good narrative for individuals, I think, based on the way things are going in the world. But the key thing is, is there a law in place, and what was the state of affairs like at the time they stopped paying you, for example? So hopefully that kind of answers that question. But thanks as always for sending it in. I've got very limited time. I'll try answering another one more question, guys. But otherwise, I'll be back, or you can ask any one of our other associates or anyone else at the firm who does these Q&As We do them a lot, and just follow up with your questions at that point, or give us a call, as I say. So I'll take one more question. Elaine, Facebook, is asking, what are your thoughts on or recommendations on being denied EI? I was denied EI, waited 3 months for my EI file to be reviewed, and I was told by EI that my religious exemption was a personal opinion. And essentially, Elaine's just talking about, what's going on with the EI stuff. And unfortunately, in my experience so far, it has been a challenge from what I've heard, individuals getting EI, even if they are offered severance, even if there's a medical exemption or religious exemption or any kind of exemption put forward. It seems to be the general case that EI is denying people, which is, obviously unfortunate. What I tell people, and I think, Elaine, you mentioned this, is to appeal these EI decisions. So if you get denied EI, there's going to be an opportunity for you to appeal that decision and then have a separate board or set of individuals look at your case. And you may be denied a second time, but I think in general, you've got to appeal for as long as you can until you reach a final conclusion or a final appeal stage. And make your point, whether it's you had a valid exemption request, or whether it's because you were in industry where there was no mandates, and so your employer doesn't have the legal right to do what they did, or just generally because you feel as though the response from your employer does not match up with your actions in not getting vaccinated. There's some disconnect there. I think there's only so much you can say or argue in front of EI, and it's ultimately going to be up to them. So I'm involved in that. I'm helping out individuals, for example, with their EI appeals, while at the same time, trying to get severance for these people as well. But if you do need help or want to talk further about EI, give us a shout. And we can definitely do as much as we can, although to some extent, of course, it's out of our hands. It's in the government's. And again, it's just a matter of carrying it through the system as long as you can, and hoping for the best, unfortunately. But hopefully that answers your question, Elaine. And again, if you have any further questions or you want to follow up, definitely give us a call. That is my time, guys. I appreciate it. I didn't get to all the questions. I apologize for that, but I will definitely be back. And as I said, we've got multiple other Q&As going on all the time. So definitely tune in again, and I'm sure someone will get to your question. But thanks, and as always, have a great rest of your day. Thanks. Take care.